Welcome everyone to our Constitution Day 2025 talk. It's a pleasure to be here. I'm Kevin Johnson. I'm the director of the Center for First Amendment Studies. It's my pleasure to be able to talk to you about a topic today that I've done a fair amount of research on, and some of the research is more current than others, but I hope to share with you some of my recent thoughts about the Supreme Court and whether or not it's a merely political institution or if it's also just a matter of interpretation. So let me begin by talking a little bit about the Constitution Day itself. There's a little background. On September 17th of 1787, delegates gathered together to sign the Constitution. So this is the anniversary of the signing of our Constitution in the United States. So we celebrate this day as a continued day of establishment of our democracy and to lay down the framework that would establish our country. In May 2005, so 20 years ago, the Department of Education declared that federal funding for all schools is dependent on universities providing an educational program about the Constitution. So in September of 2005, that same year, the Center for First Amendment Studies became tasked with making sure that the university is compliant with this federal mandate. And so at Long Beach State, the Center for First Amendment Studies has hosted Constitution Day events every single year on September 17th, or the day after, or the Monday after, or the Friday before, if September 17th falls on a weekend. This is our 20th anniversary of that. So our center has been doing this for 20 years now at the university. Some big, some small, some smaller than this, some with 200 people in attendance. So it just kind of varies with who attends. So we're very happy that you are here. We're very happy to take on this task for the university, and hopefully you'll learn a little bit about the Constitution as it progresses. One of our emphases in the Center for First Amendment Studies is, of course, the study of the Constitution. And you can hardly study the Constitution without studying the Supreme Court. The Supreme Court is the entity that is charged with interpreting the Constitution. After Marbury versus Madison, they took over the ability to interpret what the Constitution means. So any conflicts over our rights have been settled by the Supreme Court. And so we at the Center for First Amendment Studies attempt to stay close to studying the Supreme Court, the activities of the Supreme Court, the First Amendment issues that arise in the lower courts, and we try to maintain an educational program so that the public is informed about those First Amendment issues. How many of you can name all 9 Supreme Court justices of the Supreme Court? Right? Not many, right? There's a couple that are able to do that. I always find that fascinating, and you're not behind. One of the research studies that I read indicated that 2/3 of the American public can't name even a single Supreme Court justice. Okay, so 2/3 can't name a single Supreme Court justice, and this is after a lot of the controversial hearings that have had in the Senate confirmation processes of some of our most politicized Supreme Court justices, which is fascinating, right? Only 1% of the American public can name all 9 Supreme Court justices. So the fact that 2 of us can do that today means that we are ahead of the general public. And so that's something to keep in mind. So let's talk a little bit about today's question. Is the Supreme Court political, or is it simply a matter of interpretation? There's 2 key definitions in this particular question. By political, what I mean is that it's related to the ideas or strategies of a particular party or group. This is often political when there are power relations involved that benefit one party or another, that benefit one group or another. Maybe you've been on the losing side of something that has been political, and you say, oh man, I lost because of politics, right? I didn't get that job, I didn't get that opportunity or whatever. It was a political decision. So there's often power that's involved in the way that politics operates. The definition of interpretation is slightly different than this kind of political worldview. This is the act of explaining the meaning of something. So in our case, the act of explaining the meaning of the Constitution. So then today's question, when we're talking about politics and we're talking about interpretation, what we're really asking is, does the Supreme Court consider power relations in its particular interpretations, or are they simply dependent on their own interpretations of the Constitution when they make a decision, right? So on the former view, or the political view, are they maybe aligned with economic interests, and so they're appeasing that? Are they aligned with their political party, and they're appeasing that when they're making their decisions? Are they using that political stuff as a basis to interpret the Constitution, right? The interpretive view is one where their philosophy happens to align with the party, right? So it's a view that says that, yeah, I may be viewed by people as a conservative justice, but my definition of the terms in the Constitution, philosophies like originalism, historical intent, and so forth, that philosophy tends to be more conservative in its orientation. So it's not, in that interpretive view, my making a decision to appease my party. It's that I'm a part of the party because that's my view, right? So are we going to be independent then of our party and rule against our party maybe when that interpretation differs? Am I going to stay with my interpretation? So this is kind of the difference between these two ways of thinking about the Supreme Court. Lots of people think that power plays a large part in their interpretation. Lots of people think that it's just their interpretation that weighs in their decisions. And there's a lot of gray area in people that have kind of a mixture of stuff. Maybe in some cases they do use power in politics. Maybe in some cases they do merely interpret the Constitution, right? And so it's a complicated kind of game. So I want to begin by unpacking some of the factors in these interpretations. The case for the political view, the idea that the justices interpret this document politically for their own ends, rests on a number of arguments. These arguments are, I think, the most predominant arguments that are made that link the political view to the way that the Supreme Court interprets the Constitution. The first is that justices are selected in a political process, right? How can a justice not be political when a political party is the one that's nominating and confirming the justice in the first place, right? So it would make sense then that you would have a conservative justice if they are nominated and approved by a conservative majority or a conservative president. Or it would make sense that you would have a liberal justice if they were appointed by a liberal president or a liberal Senate, right? And so this kind of view it impacts the selection of the justices based on politics at the outset by how they take their office in the first place. The second is that decisions of the court often result in a winner and a loser. Thus, all decisions will have a political effect, right? So the political viewpoint is that if the side that's more associated with the liberal side loses the case, therefore it must be political in the way that I've interpreted the Constitution, right? Rather than an effect of the interpretation, it's really viewed as a position of power. It would make sense if you have a political ideology that rules against those that oppose your political ideology, right? When that happens, then we are pointing to a political view in that particular case. The third is that judicial power itself is political. So the Constitution itself is a political process. Not all agree with the Constitution. Even the Bill of Rights people don't agree with, right? It's the idea that we don't even know what these amendments mean, right? And because the judicial power itself is political in terms of the checks and balances at the very least, that power that's given to the Supreme Court makes it political, right? I get to make the decision. So politics is often viewed as who gets to make the decision is the person that is the political power, right? And so that in that view, whenever you make a decision, you cannot not have power if you're the Supreme Court. You make the decision, and that itself is part of that political process. The fourth is that justices get money from other sources besides public compensation, right? So, for example, Justice Barrett has been on a recent book tour. If she were to hear a case that involved publishing generally, one might say that there might be a conflict of interest, right? And by ruling in that particular case, it might impact her particular book sales, right? That case isn't on the docket, as far as I know. We are going to study that as part of our first Monday event with the political science department to be able to figure out all the cases that are on the docket. So look for that the first Monday in October. We'll have a program on that. But the question becomes as to whether or not the other forms of compensation that the justices get besides just their salary and benefits for being a justice impact or influence their decisions, right? There's a number of ways that justices have money. They invest in particular investments, right? They have their own property, their houses that they live in. They have their own book deals. They do speaking appearances, right? There's a whole host of things that may impact their ability to be seen as impartial arbiters of the Constitution when they have these kinds of interests aligned. And then the last one is that the court relies on legitimacy for checks and balances, right? We had this issue early on in the Supreme Court where the Supreme Court basically ruled that the Trail of Tears would have been unconstitutional, and Andrew Jackson, president at the time, said the Supreme Court has interpreted the law, now let them enforce it, and he went ahead and did the Trail of Tears anyway, right? So the question then becomes, how does the Supreme Court maintain its legitimacy as an institution with the public's trust, the public's credibility, the public's potentiality, and how does it maintain its place in the system of checks and balances such that Congress and the president don't just ignore it altogether and say, that's fine, you interpret it, go sit in your fancy white building across the street, and we're going to actually run things over here, right? And so there is a political thing where the Supreme Court may be less independent in this particular view, that the political view is one where justices care about how the public sees its decisions, if it always sides with its political party or not always sides with its political party, etc., right? So this view of the political view rests on these kinds of assumptions. The case for the interpretive view is that, number one, attacks are made by the political branches to make it appear political, that it serves the branch's interests. The argument here is simply that, of course, they want the public to view it as political and not interpretive. That benefits the legislative and the executive branch more, right? If the only way you ever understand the Supreme Court is through your memes, your TikToks, your social medias, the different media landscapes that cover those things, if you read news stories from Fox News or MSNBC, or you read about them from the major media outlets, and you don't read the Supreme Court opinions themselves, then that benefits the legislative branch and the executive branch, because now you're viewing it as a political institution, and the more you view it as a political institution, the more power the executive and the legislative branch has. Why? It's because when you view it as political, the Congress and the Senate and the presidency are arguably much closer to the political will of the people, right? They're the ones that are more directly elected. The president less so through the electoral college, but the Senate and the House being more directly represented or elected every 2 to 4 years. They theoretically at least have a more in-touch basis with what the American people want. So the more that the Supreme Court is viewed as political, the more the Congress and the president benefit, because they can say the Supreme Court is political, they've lost their mind, listen to what the Congress and the president have to say instead, right? So when I say, as Andrew Jackson, that the Supreme Court has interpreted the law, now let them enforce it, I'm going to enforce what I want because that's what the people want, right? And because the people want it and they elected me and they're political anyway, I'm closer to the political reality of what people want in my interpretation of events, so I can move forward. So it actually benefits the kind of power that the executive and the legislative branches would have if they can delegitimize the Supreme Court based on not having it be viewed as a matter of interpretation, but viewing it as a matter of politics. That make sense? Okay. The second argument for the interpretive view is that political people will always see the political. There's always a confirmation bias with that, right? If the Supreme Court makes an interpretive act and it aligns with the politics of who appointed them, they're going to see, aha, see, they're political. They acted politically because they ruled in their favor. In other words, the critique of the power perspective from the interpretive perspective would be that in order to prove that the justices don't act politically, they would have to rule against their political interests in every case, right? If they didn't rule against their interests in every case, then they're always going to be accused of being political, right? That makes sense? So and that's the only way I can prove it, because in the instances where I do vote along the party, and I do agree as a simple matter of interpretation, you're always going to confirm that bias and say, aha, I told you they're political, they ruled in the favor of their party, right? So the only way to really prove that is to rule against your party in every case, and then they can say, oh, that justice must not be ideological or political in that kind of way, because they're interpreting against their party all the time, right? So that's one of the arguments that the interpretive view makes. And then the third is that they argue that the data doesn't reflect the political decisions of the court. So the interpretive view would say that if you really look at the data of these political splits, you would really understand the political splits not in terms of politics, but in terms of interpretive philosophy. That it's more accurate to say that it's an interpretive exercise, otherwise you would have 6-3 decisions all the time. Right? You would have 6-3 decisions in every single case in our current court because we have 3 Democrat appointees and we have 6 Republican appointees. And so you would have a political split of 6-3 in all the cases. So the interpretive side says it can't be all political all the time. Otherwise, how do you explain that Justice Gorsuch and Justice Barrett would disagree with each other in a case when they're both President Trump appointees, right? And so the interpretive frame would say that it's not about political power all the time, that it is a matter of interpretation. So the data that they point to in this particular frame would be something like this. So this is the alignment of in all cases by justices. So in all the cases that the Supreme Court heard in 2025, these are the justices that aligned. So if you take a look at here, Alito, he aligned with Justice Thomas in 97% of all cases, right? So of the 66 cases that were heard by the Supreme Court last year, they aligned in 97% of them. Kagan aligned with Sotomayor, 92%, right? You have a 91% with Kavanaugh and Roberts. You have a 91% with Barrett and Kavanaugh, right? You have a 94% with Jackson and Sotomayor. So these are really interesting numbers to see, right? Jackson, 89 with Kagan. One of the more interesting ones from the interpretive view would be on Gorsuch, right? So you have a President Trump appointee that is in alignment and nowhere even in the 80s, right? He's like the most common to be different from the other justices in his rulings, right? Do these numbers make sense? So when they're looking at these, you know, if you have Sotomayor here, and then you come up here, there's alignment with these 2 justices quite a bit. If you go with Alito, there's alignment here. And then Alito here, not much alignment. I mean, there is more alignment kind of here with Kavanaugh and Barrett, right? So there is certain tendencies to kind of look at that might point in the direction of these. But this is a very fascinating kind of image to kind of look at. The other part of this is that this is the alignment in 6-3 and 5-4 cases, right? So in cases that are decided by 6-3 and 5-4 opinions, these are the alignments. So when it's a 6-3 or 5-4 opinion, it's more likely that Alito and Thomas will view each other as 100% together, right? Kagan and Sotomayor in 6354, 95%. And yet you still have this Gorsuch figure that is not always aligned in those cases, right? You still have, a somewhat interesting thing going on with Kavanaugh in 6-3 cases. 80% of the time with Roberts and 80% of the time with Barrett, right? And so you're not having these strict alignments all the time. Conversely, these things stand out and are like really significant, right? The degree to which Thomas and Sotomayor are going to be agreeing with each other is 0. They don't agree with each other at all in 6-3 and 5-4 opinions, ever, okay? That tells you that they're most likely to be polar opposites, right? So there's some really fascinating data to be shared from the 2024-25 term. This is another part of the data here. So of 66 cases in the 2025 term, you see that 26 of those cases were decided unanimously as 9-0 decisions, okay? You see that 8-1, there's 5 decisions, 8-0, there's 2 decisions, 11 that were 7-2s, 10 that were 6-3s, 10 that were 5-4s, 1 5-3, and 1 4-4, okay? So that means that 10 of the 66 were 6-3 splits. 15% roughly were the 6-3 splits. 6 of those were ideological splits. So if you take a look at the traditional split between Republican and Democrat appointees, the split between the 3 Democrat appointed justices with Jackson, Kagan, and Sotomayor, and then the other 6 more conservative appointees, there were only 6 cases of the 66 that were ideologically split 6-3 decisions, okay? 44 of those 66 were unanimous or near unanimous. Those were 7-2 or greater. 67% of the cases were decided by 7-2 or greater. And Chief Justice Roberts was in the majority more than any other justice. 95% of those cases that went 6-3 or 5-4, Chief Justice Roberts was in the majority, okay? Don't know what to make of that, per se, but those are the numbers. So the interpretive case says that it's better to view the Constitution and the Supreme Court in terms of how they interpret the Constitution to account for these nuances, right? How do you account for the fact that Gorsuch wouldn't align with all the other justices? How do you account for the fact that Chief Justice Roberts would be in the majority 95% of the time, but not the other justices? How do you account for that as an arguer of the Supreme Court? If you are actually presenting your arguments, the interpretive view would say, why would you spend time as an arguer arguing your case in court at all if it's merely just a matter of power and politics, right? It's a waste of your breath to even argue in the court. The interpretive view says there may be some interpretive possibilities to figure out how these justices view the Constitution and maybe argue from their perspective, right? So from this, they draw on Bobbitt's modalities of constitutional interpretation. In his book, Philip Bobbitt said that there were 6 ways that people basically interpret any legal kind of doctrine, but they interpreted the Constitution particularly in this way, okay? And each justice then interprets the Constitution based on one or more of these modalities of interpretation. So some justices might package and be more historically oriented. Some justices might be more ethically oriented. Some might be more textually oriented, etc. So let me talk a little bit about these 6 so that maybe this can help you understand your interpretation of the Constitution, right? The first of which is a historical interpretation. Sorry. Let me get a drink. The historical interpretation basically says we should interpret the Constitution based on what it meant at the time that the democracy agreed on it, right? So in order to figure out what it historically means for the First Amendment, we go back to the ratification debates. What were people talking about at the time when they agreed on this First Amendment? What were people discussing, right? And so if you view it historically, then that's going to come to define the nature of rights differently. This has been an issue, for example, in student free speech cases, right? Those who advocate free speech say that there's a principle that's involved with free speech, that we would extend free speech to students on our public campuses. Those that use the historical modality might say, look, if you look back at when we agreed to this First Amendment, there was no discussion about public schools, right? The First Amendment wasn't about public schools. It was about protest in public squares and things like that. The university wasn't even a figment of their imagination. It wasn't until well after that that Thomas Jefferson was able to get the first public university at the University of Virginia. So somebody like Justice Thomas, who views the historical interpretation, says, Tinker versus Des Moines was bad precedent, should be overruled. It's not consistent with the Constitution. And it's not that students shouldn't have free speech rights, according to Justice Thomas. It's that that's not in the Bill of Rights. That's not in the Constitution, right? If we want students to have free speech rights, there's a way to do that. We can legislate that, right? That's what states can do. All those things that are not enumerated in the Constitution can be granted to the states. And if the states want to grant First Amendment rights to students, that's appropriate in a democracy that they do that. But for a federal justice to be involved in this case and say there's a right in the Bill of Rights, he doesn't see any discussion at the time that the First Amendment included schools. So he's not going to say that First Amendment rights should exist at schools, right? So you can see how that interpretation would then influence the outcome of what that right would be, right? The second modality is a doctrinal modality. Doctrinal modality is based on this notion of stare decisis. It's the idea that we have to have some predictability in the law. So when the Supreme Court rules in a case, they're setting a precedent about that moving forward that we've agreed to base all of our legal decisions on. So if the Supreme Court says, hey, we have free speech rights on our campus, then that means that we have to reasonably know that that's the rule and not just overturn precedents at will, right? Because if we do that, then we're just going to be flip and flopping, and nobody's ever going to know what their rights ever are if we just start undoing all of our precedents, right? So stare decisis is rested on this idea that the definitions of the Constitution come from our interpretations of them as a Supreme Court. So in that case, you might take a look at that doctrine of Tinker versus Des Moines and say, look, we've ruled that students have free speech rights. So when this student comes to me and they say, hey, I have the rights and this administrator, discriminated against or violated my First Amendment rights on campus, I can't simply just say to the student, no, you don't have rights when I've already told you have rights, That's not the basis of any law that can exist. So those who interpret it doctrinally are heavily invested in stare decisis to make sure that our decisions are as consistent as they possibly can be, okay? The third modality is the textual modality. Textual modality just takes a look at the text of the words and it says, does the word meet the thing, right? So if we open up a dictionary and we take a look at what free speech is, and you want to come into my courtroom and say, you have digital rights to type whatever you want, I'll say, look, typing is not speech. It's not freedom of speech. You might have a case with freedom of press. We can kind of go down that road. But if you're arguing speech, if you took a speech class and you were required to just type on your computer the whole time, you'd probably be pretty upset as a customer because the speech is not typing, right? So if you're saying you have a right to type under freedom of speech, textually, that's not true. Speech is not typing. Case dismissed, right? So the textual could also influence the way that we interpret the rights in the Constitution. The fourth modality is a structural interpretation. The structural modality says that there are conflicts within the rights themselves. So we have to come to define those rights to balance and make sense of these rights when they compete with each other, right? You have the right to be safe and secure in your possessions, but others also have the right to bear arms. These conflict possibly in cases, right? You have a right to assemble with your friends, But if you do so in blocking their right to vote because they can't get to their polling place, not probably okay, right? We balanced certain conditions under which you can exercise that right. You have a right to gather, but you can't gather in front of a fire hydrant because there's a public safety concern, right? So there's a whole host of rights that need to be balanced in these particular ways. And then the fifth is an ethical interpretation. This view says that we interpret the words of the Constitution based on certain values, right? That there was a wisdom of the framers in defining these values more generally so that we can then apply those values to the current case when we hear it, right? So the example of it being different in that computer typing case, it would be that, so it's not just speech as a textual, right? There's a certain value behind free speech. It means to be able to express yourself, right? To be able to communicate things to other people. And the fact that you communicate and express yourself through an online format by typing, that's fundamental to that value that we have when we're talking about freedom of speech, right? So we're going to define the freedom of speech to include that kind of ethical principle and ruling that you have a free speech right to your computer communication, right? And so we have this kind of ethical way of interpreting the Constitution. And then the last one is a prudential interpretation. The prudential interpretation is often a definition that is advanced by the court to make sure that the system can still kind of work, right? If I rule in a particular way in the Constitution and I say, everybody has a right to do this, and then tomorrow 150,000 cases flood the court system, our judiciary isn't going to be able to handle that influx of cases, right? And so maybe the Supreme Court says, yeah, it sucks, rights were violated, but those who are aggrieved from this point moving forward are the ones that this policy is going to apply to, right? Or they can rule prudentially and say, yes, students have First Amendment rights, but in Morse versus Frederick, the principal of the school should also qualify for immunity, so that in that kind of gray area of when the principal is cracking down on a student and whether or not they're protecting the student's safety or they're protecting the student First Amendment right, even though there's a gray area kind of there, we don't think that the right should include taking a principal's house or making them lose their house and paying personal damages because that right wasn't so clear, right? Pragmatically, if we did that, nobody would ever want to be a principal in the United States, right? We wouldn't be able to have anybody run a public school. And so we need to rule that the right kind of exists in this kind of way so that our administrative things can still function, okay? So these 6 kind of interpretive modalities then frame a lot of the way that the Supreme Court interprets the Constitution. Now, whether or not these function politically or merely as a source of interpretation, that's the conflict in the 2 ways that people can view the Supreme Court, all right? So to summarize here, the main differences between the political and the interpretive perspectives, in the political view, you see that party or money influences the decision, right? This is the view that the politics or the money of a justice is going to influence their interpretation. They're going to then draw on those modalities to suit their political purpose, personally, right? In the interpretive view, the arguments influence the decision. It's about how good the attorneys are in arguing, right? If I know that Justice Thomas doesn't think that there's a free speech right for students on campus, then maybe I need to argue in terms of an individual rights premise of the student. Not that it's a free speech exercise, but it's a part of them being safe and secure in their possessions, and argue it from that perspective, right? As an individual citizen of the United States and not as a student having rights, because I know that he doesn't think that's historically bound. And then I can review what safe and secure in your possessions means historically to individuals that are in areas of public life, including public schools, to be able to try to persuade a person like Justice Thomas, because I know that the other interpretation isn't going to work as well, right? They'd argue that that it's not party or money that influences decisions, but it's the attorneys, it's the briefs, it's the Supreme Court meetings that they have behind closed doors, where the Chief Justice gets to decide the order in which the justices release their opinions, right? And then they can make arguments with each other in those particular sessions. In the political view, they argue that the decision is predetermined. It doesn't matter what briefs you submit. It doesn't really matter how you word your briefs. They're just going to decide the case the way that they're going to decide it. And the interpretive view is the idea that persuasion may influence the decision, the way that a brief is written, the way that an attorney answers a question might sway a particular justice in a particular moment, right? The other part of the political view is that oral arguments would be irrelevant. It doesn't matter. They would just view it as a spectacle. It's just performative, right? And so the justices are performing their ideologies, and the attorneys are performing their ideologies, and they're doing it for the public to kind of hear. And so the oral arguments are just kind of a ritual exercise that really don't mean anything. From the interpretive view, the oral arguments offer opportunities. It offers opportunities to try to get to inside of a justice's head a little bit, right? Just make them maybe see something in the briefs that they hadn't seen before, help them think through an issue from their interpretive perspective in ways they might not have considered, right? To meet the justice kind of where they're arguing from. The political view says that the predictions are rooted in party ideology, right? Whereas the interpretive perspective says that the predictions are rooted in the modalities of interpretation. If there's no historical basis, if there's no historical argument in any of the briefs, if there's no historical argument in the oral arguments, then those that view the historical argument as being most important are probably going to decide based on their historical interpretation, right? And so the argumentative possibilities were not taken, and so those predictions would be rooted in how the modalities function in a particular argument. And also in the political view, the justices are conservative or liberal, right? And this is a big one, even amongst scholars, even amongst myself today, right? Today, I've even talked about the justices as being conservative and liberal, but the interpretive view would say that whole label is completely wrong. You should not view it as a matter of conservative or liberal, that is just not descriptive or useful in any given way. Yes, you can argue that a decision may have been flawed. Yes, you can argue that a decision impacted people in bad ways, right? You can argue that a decision impacted people in good ways. You can make those kinds of arguments, but framing those in terms of conservative or liberal is further evidence of making that court a political entity rather than an interpretive one. The interpretive view then says that the political view doesn't explain the same ideology ruling differently, right? That scholars of the court, people who are trying to understand the court, are better served by studying it from an interpretive perspective because it's more accurate in understanding the complexities of the way that the court functions. In fact, my best example of this is in Bush v. Gore, right? We all think about Bush v. Gore in 2000 as deciding the outcome of the presidential election, where George W. Bush was basically by default named the president of the United States, right? Most people think about that as being the kind of apex as one of the political decisions that the Supreme Court made. However, what's interesting about it from a political perspective is that Justice Souter was part of the four, right? Justice Souter had decided with many of the liberal justices over time, but Justice Souter was a George H.W. Bush appointee, right? And George H.W. Bush appointed Justice Souter, and then Justice Souter ruled against Bush and Bush v. Gore, right? So I'm sure that the Supreme Court would say that if it were political, you would expect the literal person that appointed you, that you would be backing their family when it came to the presidential outcome. And that wasn't the case, right? And so we have these cases over and over again where the political view doesn't necessarily explain the same ideology ruling differently within these parties. And further, the implications of that would be that it would delegitimize some of the legitimacy of the Supreme Court in the process and put more stock in the executive and the legislative branch, which is why it's also not surprising that most people in the United States can name the President of the United States and maybe even name their senator, but they can't name the 9 Supreme Court justices that are there for life appointments, right? Because they view it more as political. So the takeaways of scholars, people who study the Constitution as an educational program on Constitution Day. I find it significant to study both politics and interpretation, right? This is not an either or. We would be remiss if we only studied one part of this equation. We have to study both the interpretive complexities of the court, but also the power politics of the court. We have to be able to argue and to think through, are there particular cases where justices should have recused themselves for conflicts of interest? Are there standards of ethics that ought to be implemented to have the Supreme Court guide itself and in ruling in terms of its own ethical behavior, right? And at the same time, we have to be viewing this as an art of interpretation, of looking at the way these Supreme Court decisions are written and relying on an unmediated literacy in many ways, right? So as scholars of the Supreme Court, it's important that we actually read the Supreme Court opinions. If you haven't read a Supreme Court opinion, I strongly recommend it. If there's fancy words in there that you don't understand, I would argue that that's okay. Keep reading. Read on, right? Skip over it for now. You don't have to continue knowing everything, but you'll be surprised with how simple a lot of the Supreme Court decisions are to read. They're not like many other legal cases and legal briefs. Supreme Court decisions are usually written fairly accessible to read the fact pattern, to read the events that led up to the lawsuit, et cetera, so you can get an unmediated perspective. I'm always blown away by the fact when I read headlines from different media sources that say the Supreme Court ruled this, and I'm like, I read the decision. I didn't see that anywhere in the decision, right? That's not what they ruled, right? But it doesn't make the spectacle. So I think it's important as scholars that we study both the power and the interpretive schemes. The second is that politics is significant in terms of confirmation hearings, Supreme Court legitimacy, and conflicts of interest. We have to take a look at the way that power and politics influences this, and this is a lot of the work that our political scientists really do on a regular basis. The third is that once you're arguing, the interpretive is the main source of agency, right? Like, you could think to yourself like, hey, I'm going to try to bribe a justice, but that's against the law, right? But once you're arguing as an attorney, what good does it do then to think about the power perspective, right? Well, if you're going to rule against me anyway, I'm just going to sit down. Really? You're just going to give up as an attorney? Probably not, right? So at least what happens is that once you're arguing in front of the Supreme Court, like quite a few people that I know have, the interpretive is what creates that main source of agency to potentially think with justice, to be able to try to get them to be able to pull and understand your idea from their perspective, not just what you think. Because not always the argument you think might be the winning legal argument might actually be the losing argument to the justice. And the argument you think is a weak argument might actually be the persuasive thing to a justice. And so that's part of the process to kind of unpack. The next is that the interpretation is not inherently liberal or conservative. We had Justice Stevens, for example, who was a more conservative justice in terms of being a President Ford appointee for the Republican administration, but Justice Stevens argued from a historical interpretation based on the Citizens United case against Justice Scalia and created arguments that were completely opposite. Just because you're arguing from a historical modality doesn't necessarily make you inherently conservative, right? And so to be able to engage in these as argumentation premises is more accurate than just saying, well, let's see what the Liberal Party believes and let's see what the Conservative Party believes and argue that point, right? It's more complicated than that. And then the last part is that liberal conservative framing does not account for the nuances and differences within those frames, right? Why those conservative justices disagree. As a person that studies rhetoric and persuasion and the contest over meaning, this is particularly fascinating to me. How do you make sense of when Justice Gorsuch disagrees with Justice Barrett when they're appointed by the same president? How do you make sense of when Justice Kagan disagrees with Justice Sotomayor, right? How do you make sense of when Justice Sotomayor disagrees with Justice Jackson, right? Those are important places for me as a scholar, because those are where the places and nuances of persuasive possibilities may come from, right? It shows kind of their kind of differences and their subtle kind of nuances, okay? So I think those are the kind of takeaways as scholars. So in conclusion, I want us to take from today the idea that the Constitution is a really dynamic entity. It's something that's ongoing. It's something that is interpreted. It's something that the Supreme Court regularly is in the business of. It's something that we're in the business of, right? What kind of Constitution do we want to have in terms of its meaning? How do we want certain things to mean when it comes to our confirmation hearings, right? If a justice is interpreting a Constitution in a particular way in the confirmation hearings, and you're like, wait a minute, that interpretation sounds like not even rooted in one of these modalities. Like, this is kind of far off from any like real basis. Maybe that's a qualification mechanism we use as a democracy to have our senators possibly not confirm, right? Maybe it means that we take a look at different justices from different viewpoints, right? One of my favorite facts, does anybody know which Supreme Court justice is the only current justice to be both appointed by a Republican and a Democrat president? Anybody? No? Huh? Nope. Justice Sotomayor was appointed by George H.W. Bush to the federal bench to begin with, and then was appointed by Barack Obama to the Supreme Court. So she has both a Republican and a Democrat nominee, right? So, I mean, there's fascinating things to take away from this politically, interpretive. The point of it is that the Constitution is a dynamic thing, right? It's something that is ongoing. It's something that is the subject of all the cases that we hear in front of the Supreme Court. What should the Supreme Court, what should the Constitution mean? And I invite you as participants in democracy to be able to think about what the Constitution means to you, right? What does it mean to us? You know, I can speak to you all I have about this expertise in studying the Supreme Court, but at the end of the day, we all share power. That's what democracy is about, right? Your vote counts just as much as mine, right? And so how do you want the Constitution to be interpreted? What does it mean to you? In order to invite reflection on those questions, I really, really invite and encourage you to give some time, a little bit of time, to reading Supreme Court opinions that are important to you. If you think that issues like abortion and gun rights and gun control and any number of states' rights cases or immigration cases or war and peace or commerce or all these kinds of questions, if they're important to you, then there's a way in which you can spend time thinking about them. Focus less on the mediated and focus more on the unmediated. The amount of time that you spend on the unmediated is going to help you understand the issues, I think, better than you would from any news story, from any TikTok thing that you'll get, from any Instagram post, from any Snapchat discussion that you have with a friend and so forth. The more unmediated it is, the more reflection you're going to be able to have. So even if you're able to, I know a lot of us don't have a lot of time. Time is of the essence, right? And I don't have the time to read all 66 Supreme Court cases in a term. But if there's an issue that you see in a headline, right? So say that you see a Supreme Court decision in a headline and you're like, wow, that issue is huge and that one's important to me. Instead of reading more about it in the news sources, look up the case name, go on to on the web. Cornell has one, the OIA website has one. The Supreme Court actually publishes its decisions on the supremecourt.gov site, right? find the case itself and just open it up and start reading, right? It reads better than you think and easier than you think. And I can guarantee you that if you can spend 5 minutes reading a Supreme Court opinion versus 5 minutes of reading a mediated kind of outlet about it, you're going to understand for yourself what you think the Constitution ought to mean, whether or not you want to dissent or be in the majority of opinion of a Supreme Court decision, and whether or not you think that they got it right or wrong, and how you might want to work to try to change the evolving nature of the Constitution moving forward. Okay?